Hello everyone, welcome back to our Learning Legal English through Case Laws series. In this video, we will study Case Law N0.28/2019/AL about manslaughter under provocation. Including 5 parts: Part 1, Source of the Case Law; Part 2, Overview of the Case Law; Part 3, Content of the Case; Part 4, Assessment of the Court; Part 5, Rules. This case law was approved by the Council of Judges of the Supreme People's Court on August 22, 2019 and published under Decision No. 293/QDCA of the Chief Justice of the Supreme People's Court on September 9, 2019. Part 1, Source of the Case Law. The Cassation Decision No. 16/2018/HSGDT of the Council of Judges of the Supreme People's Court on September 25, 2018 on the case of manslaughter under provocation to the accused Tran Van C., born in 1991. Part 2, Overview of the Case Law. Case law situation: the victim has committed a series of illegal acts to attack the defendant, continuously leading to the defendant's psychological inhibition and mental agitation. In a state of incontinence, the defendant stabbed the victim with a knife to escape the attack. The defendant is not fully aware of the nature and extent of danger of the acts committed. The consequences was the death of the victim. Legal resolution: in this case, the accused must be prosecuted for criminal responsibility for the crime of manslaughter under provocation. Key words of the case law: manslaughter under provocation, be strongly mentally agitated, incontinence. Part 3, Content of the Case. About 23:30, November 3, 2016, Tran Van C. was playing game in the internet cafe in Group 1A, Ward N, District K, Dak Lak Province. His friend Nguyen Hong Q called him and asked him where was he. Then, Nguyen Hong Q came and used the 6th computer in the internet cafe. During that time, Q repeatedly went to C's position and asked to borrow money, but C said he had no money. Then, Q came to C and gave C his 2 mobile phones and asked C to pledge to borrow money. C still disagreed, so Mr. Q left his place to continue playing games. 15 minutes later, Q came to C and said, "You don't trust me, do you? Please help me." C said, "I don't have money. Please leave me alone to play game." Q cursed, "Woe betide you." C said nothing. Q was back to his computer. A few minutes later, Q came to C's position, beat C's left cheek with Q's right hand, causing C to bleed. Being beaten, C got angry and took a tie knife on the table, between 2 computers with his right hand and stood on the chair. Then, Q rushed and C struck him with the knife, causing him to bleed. Q pulled C to the chair with his both hands, held C's neck. C's head was behind Q and C's body was in front of Q. Being held by Q, C grasped the right hip of Q with his left hand, held the tie knife with his right hand and stabbed Q's chest. Nguyen Hai Q1, playing the game, snatched the knife in C's hand and threw it into the corner of the internet cafe. At that time, Q fell down. C and the others in the internet cafe took Q to the hospital for emergency. On November 4, 2016, Q was dead. After that, C went to the police of District K to surrender. On November 4, 2016, Q was dead. After that, C went to autopsy results of Mr. Nguyen Hong. Question: the left forehead area above the eyebrows has a 0.7 cm long slit-shaped tear. The tip of the nose has a 2 cm long and 0.4 cm deep slit-shaped tear. 3 cm from this spot to the upper lip is a slit-shaped tear with a length of 2 cm. The right edge has a 0.3 cm long and 0.8 cm deep slit-shaped tear. 3 tears create a discontinuous line from top to bottom, from left to right. There is a 1.3 cm long horizontal slit-shaped tear in the chest, 3.5 cm below the right nipple, 9 cm from the middle line. There is a 2.5 cm long, 0.1 cm wide horizontal slit-shaped tear from left to right, from front to back, from outside to inside. It's in the left chest, 120 cm from the left heel, 0.5 cm from the middle line. At the conclusion of the autopsy report number 714/QPY on November 24, 2016 by Division of Criminal Technology of Dak Lak Province Police, the cause of Mr. Nguyen Hong Q's death is a penetrating wound on the left chest that caused a penetrating heart wound that leads to cardiac arrest and irreversible acute bleeding circulatory failure. At the conclusion of the forensic tests number 113/PYTGT on January 4, 2017 of the Forensic Center of Dak Lak Province, Tran Van Si has the trauma to the left cheek makes a 2% injury. Before the first instance trial, Tran Van Si's family compensated the victim's family for 95 million VND. At the first instance criminal judgment number 14/2017/HSST dated May 9, 2017, the People's Court of Dak Lak Province applied Clause 1, Article 95, points B, H, P, Clause 1, Clause 2, Article 46 of the Criminal Code. Tran Van Si carried a penalty of 0.2 years and 0.6 months of imprisonment on charges of manslaughter under provocation. According to the Article 42 of the Criminal Code, Articles 606 and 610 of the Civil Code, C was forced to compensate the victim's family for an amount of VND 122,600,000. He compensated for VND 95 million, so he had to pay for an amount of 27,600,000 VND. C was forced to provide support for Q's son Nguyen Hong M an amount of 600,000 VND/month. For Q's newly born child, Q's wife, LUhet T had the right to sue another case for the support. In addition, the first instance court also decided on the handling of the evidence and court fees and declared the right to appeal in accordance with laws. On May 22, 2017, the legal representative of the victim, Ms. LUhet T appealed and proposed to apply Clause 2 of Article 93 of the Criminal Code to Tran Van Si and increase the penalty. At the same time, she proposed to increase the amount of support for Hong M and request to determine the responsibility for support for Q's newborn child, Heidi, born on April 29, 2017. On May 24, 2017, Tran Van Si appealed for a penalty reduction. In the Criminal Appellate Judgment number 200/2017/HSPT dated August 10, 2017, the Collegial People's Court in Da Nang, based on points A, B and C, Clause 2, Article 248, Clause 3, Article 249 of the Criminal Procedure Code, not accept the appeal of defendant Tran Van Si. Accept the appeal of the legal representative of the victim, amendment of the first instance judgment on the consequences of the crime, applying Clause 2 of Article 93, points B and P, Clause 1 and Clause 2, Article 46 of the Criminal Code, forcing Tran Van Si to carry the penalty of 0.7 years of imprisonment for murder. Partially cancelling the first instance judgment related to the responsibility for supporting the victim's children, hand over the files to the People's Court of Dak Lak Province for resettlement in accordance with laws. In the judgment number 47/2017/HSST dated September 14, 2017, the People's Court of Dak Lak Province decided to force Tran Van Si to support for Nguyen Hong M and Nguyen Hang D for 650,000 VND/month/child. At the decisions number 15/2018/KNHS dated May 22, 2018 on protest under the cassation procedures, the Chief Justice of the Supreme People's Court decided to protest the appellate judgment number 200/2017/HSPT dated August 10, 2017 of the Collegial People's Court in Da Nang and requested the Council of Judges of the Supreme People's Court to hold the panel for cassation to cancel that appellate judgment on the criminal responsibilities of Tran Van Si and hand the case over to the Collegial People's Courts in Da Nang for a re-appellate trial. At the cassation trial, the representative of the Supreme People's Procuracy agreed with the decisions on protest under the cassation procedures of the Chief Justice of the Supreme People's Court and requests the Council of Judges of the Supreme People's Court to cancel the appellate judgment, upholding the decision of the first instance judgment on the charges and penalties against Tran Van Si. Part 4 Assessment of the Court. 1. About the crime. Based on the testimonies of Tran Van Si which matched with ones of witnesses LUhet N1 and Nguyen Van N2, there was the basis to determine the cause of the incident resulting from the fault of the victim Nguyen Hong Q. Q had a series of behaviors constantly affecting Tran Van Si, such as asking for a loan from C. Although C said that he had no money, Q cursed C and C said nothing. Q even went to the seat of C to punch him in the face, causing 2% injury. After being punched by Q, C took the knife, used to peel the fruit, available on the table, and stood on the chair back and forth, showing that C had no intention of attacking Q but preventing the attack from Q. However, Q, although C was still holding the knife, pulled C down from the chair, clamped his neck. In a controlled situation, C's head was clamped at Q's back, the rest of his body was in front of Q. C held the tie knife with his right hand and stabbed Q's chest, causing Q's death. In this case, the victim was the one who caused the attack to the accused. The victim's attack behaviors were taking place continuously with increasing levels. The victim's act was against the law and infringed on the physical safety of the defendant. In the status of being agitated leading to losing self-control and fully aware of the nature and severity of his behavior, the defendant used the knife to stab the victim to escape from the victim's attack. Therefore, there were sufficient grounds to determine that Tran Van C was strongly mentally agitated. The first instance court sentenced Tran Van C to manslaughter under provocation was dependable. 2. The appellate court did not objectively and comprehensively consider the cause and the process of the incident and the seriousness, continuity and illegality of the victim's acts when assessed Tran Van C was mentally agitated but not strong enough. Therefore, transferring the crime from manslaughter under provocation to murder for Tran Van C is not right. Part 5, Rules. According Article 382, Clause 2 Article 388, Article 390 Criminal Procedure Code 2015, 1. Canceling the criminal appellate judgment number 200/2017/HSPT dated August 10, 2017 of the Collegial People's Court in Da Nang on the criminal responsibility, crimes, penalties and court costs to Tran Van C. 2. Upholding the decision of the criminal first instance judgment number 14/2017/HSST dated May 9, 2017 of the People's Court of Dak Lak Province on the criminal responsibility for Tran Van C. Content of the case law. 1. The victim is the one who caused the attack. The victim's act was against the law and infringed on the physical safety of the defendant. In the status of being agitated leading to losing self-control and fully aware of the nature and severity of his behavior, the defendant used the knife to stab the victim to escape from the victim's attack. Therefore, there were sufficient grounds to determine that Tran Van C was strongly mentally agitated. The first instance court sentenced Tran Van C to manslaughter under provocation was dependable.